The Guide to Trust Funding, How to Transfer Assets Like a Pro. 1. The basics of transferring assets. Here's the short version. A trust is a legal box. If you don't actually put your stuff inside that box, it stays empty. Sounds obvious, but it's the biggest mistake people make. They create a shiny new living trust, pat themselves on the back, and then forget the main step, moving their assets into it. So what does that actually mean? It means you have to change the title, the ownership, on your property, accounts, or other assets so they legally belong to your trust. The trustee, that's the person managing the trust, holds legal title for the benefit of whoever you've named as the beneficiaries. No title transfer, no protection, no probate shortcut, and no peace of mind. A trust name can be as creative as you like: Green Frog Trust, Sunrise Legacy, The Secret Stash. Unlike LLCs or corporations, you don't register it with the state. So go wild. Just remember, if your trust isn't listed on the title, the law acts like it doesn't exist. Footnote: Forgetting to title assets in the trust is like buying a safe and leaving your valuables on the floor beside it. 2. How real estate gets in the box. Here's where people get fancy, or messy. Real estate has to be deeded from your name to the trustee of your trust. That's done through a warranty deed, not a quitclaim deed. Those are for people who like trouble. Example: if Stacy owns Green Frog Trust, she transfers the property from Stacy to Stacy, as trustee of the Green Frog Trust, dated January 1, 2025. Simple. The trust now owns the property. When she dies, no probate, no court drama, no bureaucratic scavenger hunt. If it's a rental or investment property, a land trust adds privacy. If it's her home, her living trust keeps it in the family smoothly. The trick is to avoid owning it personally. Why? Because personal ownership paints a big legal target on your back. A living trust erases that bullseye. Footnote: Deeding real estate into a trust is the adult version of writing your name on your lunch. It keeps others from claiming it when you're gone. 3. Funding business interests. The LLC. The little engine of capitalism. Here's the thing: if your LLC's membership interest still lists you as the owner, your heirs get a probate headache when you're gone. The fix? An assignment of interest. A short document where you say, "I hereby assign 100% of my interest in Red Box LLC to the Green Frog Trust." Then the trustee signs an acceptance. Done. The LLC is now owned by the trust, not you personally. Some folks restate their operating agreement to reflect this change. Others keep their names listed to avoid nosy lenders demanding to see the full trust. Either way, the assignment itself does the legal heavy lifting. Just check the LLC's operating agreement first, make sure it allows this kind of transfer without needing permission from other members. If not, fix it. Because nothing ruins a legacy plan faster than a technicality buried in paragraph 17b. Footnote: A trust-owned LLC passes seamlessly to your heirs, and keeps lawyers from circling your assets like sharks at feeding time. 4. Bank accounts and investments. Here's where it gets personal: money. Bank accounts, brokerage accounts, CDs, and treasuries don't move by assignment. You have to open new accounts under the trust's name. That's it. Green Frog Trust, Stacy as trustee. You'll then roll over or journal your funds from the old account into the new trust account. Your statements show the trust name, but your checks can still just say Stacy. No need to scream trust fund every time you pay a bill. If you already hold your investments through an LLC, relax, you only transfer the LLC itself into the trust. That's one move, not a dozen. So what does that actually mean? It means organization pays off. Put the right assets in the right structure once, and you avoid endless paperwork later. Footnote: Moving money into your trust is like setting up auto pay for your legacy. Once it's in place, it just works. 5. The little stuff that matters. Not everything has a title: your jewelry, tools, antiques, furniture, or that vintage coffee table everyone fights over. For these, use a personal property memorandum, PPM. It's a simple list that says, I intend to transfer all my personal effects into my living trust. No need for model numbers or serial codes. This isn't an IRS audit, it's peace of mind. The signed PPM attaches to your trust and transfers all untitled personal property with one sweep of a pen. So what does that actually mean? You're telling the universe, this all goes together. It's one of the easiest ways to keep your legacy neat, and avoid family squabbles worthy of a reality show. Footnote: a personal property memorandum is like leaving a note on your stuff that says, don't fight, it's all taken care of. 6. The big picture. Every trust is a tool, not magic. It works only if you use it. The moment you move assets correctly, you've built a bridge for your wealth to cross safely, from you to whoever comes next. That's the goal. If you skip it, that bridge collapses under probate and paperwork. And lawyers? They love rebuilding bridges. On your dime. So, set up your trust, move your assets, double-check your titles, and relax. You've done the one thing most people only plan to do: protect their legacy while they're still around to enjoy it. Footnote: a trust only works if you actually use it. Like a parachute, it's useless unless opened.